Alex here with part 103 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This video goes into my opposition to my ex's motion for attorney fees. She's trying to use Rule 11 to impose attorney fee award as a sanction. I think that I felt pretty strong about this opposition because I'd already defended against my ex's efforts to get attorney fee awards in the past, and I was successful the whole time. I think I have at this point in time fended off 3, maybe 4 different requests for attorney fees, and this is either request number 4 or request number 5. I lost track after a while. In any event, I think most of the discussion on this topic should occur in the actual, the portion of the video where I go over the document itself. So let's go ahead and take a look at what I have on file. Here we have my opposition to motion for Rule 11 sanctions and attorney fees. I am going into the standard introductory paragraph introducing myself as the petitioner, indicating to the court that I'm appearing in proper person, which means I don't have an attorney, and it looks like I do not identify the motion that I'm filing in opposition to, which is not good. It's better to, whenever possible, indicate the specific date and title of the motion that you are filing your responsive paper to, because it's not just oppositions where you should do this, it's also replies to oppositions. And in the event this opposition is based upon, and I'm going to go ahead and go straight into it. First, we have the filing of the motion to modify custody after emailing my ex's attorney. My ex paints a picture in which I am emailing her attorney with the intent to communicate about issues I have regarding education, only to turn around and backstab her with a motion to modify. I deny this characterization. On September 24th, I was notified by the attendance keeper that my ex had... Okay, so I already know where this is going. So when I contacted my ex's attorney, she had it looks like here she had 4 absences. And within that 1 week, those absences went up quite a bit. Let's see here. She went up an additional 3 absences, so 5, 6, 7. So it wasn't so much that she only had 1 week to think about it. It's, hold on a second, she's gone from 4 to 7 in 1 week. That's almost doubling the absences. It was already a concern at 4. And there is also issues with the local school district rules where if the child does not appear, I think they have to have a certain number of unexcused absences. By the way, they're not that hard to get excused. Typically, they just take your word for it. So if you call and say your child was sick, they don't check up on you. They just consider it an excused absence. All they need to do is hear from you. So my ex was not taking him to school, and she was just not calling him at all, and that's how they were turning into unexcused absences. In any event, I think it was 11. It should have been 11. We'll take a look further through this document. It'll probably come up, but after a certain number, I think 11, the child's automatically removed or unenrolled from the school. And I had strong suspicions at this point in time that my ex was trying to find a way to cause our son to be removed from the school, where she could say, hey, I didn't know, or it's not my fault, or they didn't tell me this would happen. Oh, well, now that he's not in school, let's put him in this other school. If anyone here has been watching the My Docket series from beginning to here, they would know that that is absolutely within her sort of parameters of trying to get what she wants. So the first thing I want to mention is this is a really good argument that counteracts the characterization my ex's attorney puts forth, but it is probably not the best approach. I should have initially led off with the law, which was that the court rule did not allow me to have an opportunity to withdraw basically she didn't comply with the plain language of the rule of the, more specifically of the safe harbor provision. And in failing to comply with the safe harbor provision, she is unable to get attorney fees under this rule. That would have been the quickest and most effective way of completely winning this argument. And then if I wanted to, I could have added this sort of in a second or third section further down, but that would probably be the better way to tackle that motion. This is something I talk about in some of my videos. I wish I could remember the title, but basically, as non-attorneys, we don't think the way that attorneys do. And so when we're confronted by a lawyer, we often think that we need to sort of controvert their allegations. And that's all good and well. You should do that, especially if they're lying. But sometimes that is just a way to sort of snare you into their trap of trying to get the court to consider something that was never legal from the first, place, that was never legal in the first place. And in this case, her request for attorney fees under Rule 11 is just not authorized because she didn't comply with that particular rule. Again, if you guys want to know more about why it's so much more powerful to use that, please watch my video, Statutory Construction, because in that video I go over the different rules of statutory construction and I talk about the power of the plain language rule and how it is one of the ways that you can force a judge to do a particular thing. It's one of the ways where you don't have to rely on the judge's discretion. By the way, that's another video topic. So I'm going to go ahead and move on now. We have here the filing of the discovery motions and subpoenas ducis tecum. It appears that my ex and possibly the court as well have completely misunderstood the intent behind my seeking my ex's mental health records. Here I am getting snared into intent again. I am so concerned about trying to correct the record. I'm so concerned about trying to portray myself the way that I actually intend to be portrayed that I don't realize that it's very likely that this attorney and this judge already know that none of this is true. They just don't care. What they're trying to do is find a plausible explanation or a plausible basis with which to reach the conclusion that they have predetermined should be reached. So I'm here really bent out of shape, really upset that I'm being misunderstood by not only my ex's attorney but the judge. And here I am, all these years later, sitting here reading this, and I'm like, dude, they already know that that's not what you're thinking. They just are saying it because that's what they need to say to get what they want, which is to deny the motion and impose sanctions. So the better way to deal with this would have not been to feed into what they are saying so much as it would have been to use the law against them. That was definitely a stronger approach. Using Rule 11, using her failure to comply with the safe harbor provision was for sure, 100%, undoubtedly the stronger way to shut this down. Going into, this is all intent. So I'm all bent out of shape about intent. I'm re-arguing res judicata because I'm trying to say, hey, you guys don't understand. You're applying this wrong. They don't care that they're applying it wrong. This is one of the things that could have gotten reversed on appeal. But like I mentioned, on remand, the judge would have probably found a different basis with which to rule against me anyway. That would have been only for the motion itself, though. That wouldn't have been for the attorney fee Rule 11 sanctions. That I could have defeated for sure, and they would have had no way to recover from that. My argument against the request for Rule 11 sanctions would have been fatal to my ex's attorney. Scrolling further, change of circumstances. All these things I already talked about in previous motions. I was candid with my ex and the court regarding every aspect of the motion to modify. So again, I'm going back into the NRCP 16.21 arguments. All of these things are me just trying to correct the record. Legal analysis. Let's take a look at this. Rule 11 sanctions are appropriate in a child custody matter. We need look no further than Rivero. This is true. So this is one of the cases that I discussed in my video, Defend Against Attorney Fees. In this case, the Supreme Court of Nevada makes it crystal clear that winning the motion is not enough to get an award of attorney fees as a sanction. And they cite Rule 11. They also cite these two different statutes. And these are the two statutes that I've been just destroying my ex's attorney on this whole time. That's why she hasn't been able to get an attorney fee award. Rule 11, basically, as far as I know, follows the same logic as those two statutes, but imposes an additional restriction. And that additional restriction is the safe harbor provision. So I had all of the same weapons available to me, or shield or armor available to me to defend against this, plus an additional, even stronger shield. So I was in even more favorable position at this point, but I didn't know that at the time. I didn't know how powerful statutory construction was. I didn't know that court rules had to follow the rules of statutory construction just like statutes, and I didn't know about the safe harbor provision. All these things I didn't know, and that would have just taken my argument from strong to almost invincible. Next, we have Here's further discussion on the Rivero case. Again, guys, if you want to learn more about these arguments here, please watch my video, Defend Against Attorney Fees. I've already talked about these arguments in that video. Before you get too excited, if you're in Nevada, we have a big problem now. There's something new that came out that makes it a lot easier for attorneys to get attorney fee awards. So don't get too excited when you watch that video until I should say, you watch the other video that came out later called Attorney Fee Equalizers. Here we have the next paragraph. That's still talking about defending against attorney fees. Still talking about, okay, so this actually is an interesting case if you guys want to take a look. I don't really need it though, because all the other cases that I've used are already on point. Marshall v. District Court makes it clear that attorney fee awards as a sanction are dangerous when abused. And the reason why is because abusing them has a chilling effect on a lawyer's obligation to argue zealously for their client. Part of being an attorney and arguing for a client is to do so as zealously as you possibly can. And when a court abuses its discretion on attorney fee awards as a sanction, they basically punish the attorney for doing that, which is not something that the Supreme Court is going to tolerate. By the way, if you're representing yourself, then you're acting as your own attorney. So, technically, you are an attorney representing yourself, the client. And yes, you do have a right to represent yourself zealously. Next we have, and I think they also mentioned that you can't use the wisdom of hindsight. It's one of my favorite things here. The court should avoid employing the wisdom of hindsight in analyzing an attorney's action at the time of the pleading. You have to look at what the situation was at the time it was filed. You can't look and say, hey, look at all these other things that have happened after the fact, because the attorney at the time of filing it was not able to see into the future. Now we have another case, it looks like. I don't think I needed this case for sure. This is just another nail in the coffin designed to destroy my ex's argument on requesting attorney fees as a sanction. So same thing, guys, just throwing another case in there. I didn't really need to do that. I had plenty of cases to shut them down. We have attorney fee awards, even if granted, can be mitigated. And here I'm citing Bergman v. Boyce. This is a case which explains that just because somebody is found to have brought colorable claims doesn't mean that the court should assume all of the claims were, not colorable, colorless, or that's the term, groundless, colorless, something like that. Anyway, what this case does is it tells the court that if you're going to impose attorney fees as a sanction, you need to make sure that you pick apart the portions of the claims that are actually meritless. You don't want to punish them for everything. You just want to punish them for the ones that were brought without a reasonable basis. So I'm trying to say here that, hey, if you have a problem with what I've done, you should award attorney fees just on those specific things that I have done that are not reasonable. It's a good case. I think that's a good thing to include. We got here, basically, I'm going into the fact that attorney fees, even if granted, should be offset. This is me recognizing or trying to bring to the court's attention the fact that my ex owes a bunch of money in a child support to me, and that even if the court thinks that I do have to pay some kind of money to my ex in attorney fees, that should be offset by the amount that she owes me in child support arrearages. This is a good thing to bring up at any time where you're facing some kind of award that your ex might get when your ex already owes you money in the first place. And if you want to learn more a little bit about offsets, please watch my video on the topic. I think it's titled Offsets and Set-Offs, or vice versa. Here we have a list of examples of things that I could have done but didn't do that would have entitled my ex to NRCP 11 sanctions. Again, I'm going to skip over this because I understand that at the time I thought the court misunderstood me. I thought that my ex misunderstood me, but now in hindsight, this was all superfluous. I didn't need it. And the judge and my ex's attorney understood me just fine. They just didn't care. The judge, I think, wanted to reach a specific conclusion, and he was trying to find a plausible reason. And my ex's attorney was just doing her job, which was to win at all costs. If you want to learn more about that, watch the video, Win at All Costs. If you want to learn more a little bit about my judge's wrong-headed approach, you can watch the videos Self-Representation Bias, and you can also watch the video Meta Rulings. Actually, there's another good video you could watch, which is Conclusion Before the Facts. Next section here is my conclusion. This is a kind of a long-winded conclusion, but it goes into the same thing that I already mentioned, which is I'm trying to reframe myself. I'm trying to explain to the court that the characterization put forth by my ex's attorney is not actually accurate at all. And again, guys, I think the judge knows it, just doesn't care. So I really didn't need to go into all this. Even if the judge did care, I mean, he would have known on his own. He wouldn't have needed me to tell him. He would have been able to pay attention to the things I was filing. He would have read my papers. And I don't think any of these things is the case. I don't think he really bothered to get into any of that. He just wants me to stop filing papers. He just wants me to go away. And if you want to know more about this wrong-headed approach, please watch the video. End of filings is not end of abuse. I know I bring these video topics up a lot, but I think some of my viewers haven't seen them. And it's really hard to get your head around why the judges are doing things that are not in the best interest of the child until you watch those videos. Once you watch those videos, you start to make sense of why they do what they do. Even though it's wrong, you'll at least understand why they do it. Next, here is my declaration under penalty of perjury, swearing that all the factual allegations made in this opposition are true. Here we have my certificate of service under Rule 5. Next, we have the motion opposition notice indicating that I don't have to pay a filing fee for the filing of this opposition. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent a half hour on reviewing this document. I almost said 15 minutes, but it's a pretty lengthy document. I cited a lot of case law. She's going to have to consider that when she prepares her reply to my opposition. So I think a half hour for that document with all the law and the facts cited, I think it at least would have spent, or at least would have took her 30 minutes to review that document. At the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.